So to kick off this event, thanks very much for everyone for joining. Welcome to this online connected event. I don't often quote Lenin, but there's a quote that I think is kind of pertinent. He said there are decades where nothing happens, and there are weeks where decades happen. Brexit and COVID have been going on for weeks, but they could change history for decades, if not more. And they both have political and legal aspects. Legal issues have been central throughout Brexit, all the way through to the Supreme Court. And COVID has also asked us to question some of the legal bases we tend to take for granted. And in both, the financial sector has played a big role, from the importance of passporting to financial services in Brexit, to the role that banks have played in getting new lending to businesses and providing payment holidays, and generally in the economy. So I'm really delighted that we've got a great panel to discuss this, the issues of Brexit, COVID, and the financial services with us at this event, from the Society of Labour Lawyers and from the Law Society. To introduce myself, I'm Omar Salem. I'm chair of Labour City Lawyers. And we have on our panel Hilary, Benn, who of course chairs the Brexit Select Committee, and has been doing a lot of work on the issue over the last few years, grilling ministers and others on the committee. Angela Eagle, who's on the Treasury Select Committee, which has been doing a lot of work recently, especially on the economic impact of COVID, and looking at that over the last few months. David Greene, who's Vice President of the Law Society, and brings the kind of perspective from the legal sector on these issues. And Anneli Howard, who is a barrister at Monckton Chambers, and has been doing a lot of work both on the side of Brexit, but also has a lot of financial services legal expertise, which she can share with us. Before I kick off, just to say, if you'd like to ask questions, you can put questions into the Q&A box, and I will read them out when we get to the questions stage. So please do put them in as they kind of occur to you, and we'll pick them up at that point. But first of all, I'd just like to hand over to Hilary to ask him to say a few words.
Well, Omar, thanks very much indeed, and thank you for the very kind invitation to join this event this morning. I spent a lot of the last 3 years talking about Brexit and opening with the line, "What a mess." But that remains the case. We are running out of time. There are three things going on at the moment. The first is, are the negotiators going to reach an agreement? The second is the argument about the internal market bill, which we'll be considering in committee today a little later on. And the third question is how our borders are going to operate from the 1st of January, because whether there is an agreement or not, we leave the arrangements of the single market and the customs union, and stuff is going to have to be checked. And the truckers, freight forwarders, and so on, who move stuff for a living, have been saying increasingly loudly in the last few months, we're not ready. I wanted just in my brief remarks to focus on the first two, however. The government surprised everyone, Brandon Lewis, when I was in the chamber and he looked at his piece of paper when he read out those famous words, does break international law. It was not an accident. It obviously been agreed that he was going to say those things. It's all very odd when you think about it. First of all, you might think that the government would have flagged up that they thought there was a problem before they produced what they regard as the solution, which breaks international law, but they didn't do that. And secondly, their failure to put trust in the dispute resolution mechanism of the withdrawal agreement, particularly relating to the Northern Ireland Protocol, because that's what they're concerned about. They finally said last week that they would use that in parallel to using the powers that they're proposing to take in the bill. But that is clearly the wrong way round, because they negotiated the agreement. They provided for a dispute resolution mechanism, and it does give the United Kingdom, or indeed the European Union, a very clear power to take exceptional measures if they are threatened, societies, the economy, or the environment. What are the 4 things they claim they're concerned about? One is, should goods moving from Northern Ireland to GB have to fill in exit summary declarations? Personally, I have a lot of sympathy with them on this, because what is the EU going to do with an exit summary declaration on a bus made in Ballymena that is being sold to a transport authority in Liverpool? I have no idea. They're going to file it. But is it worth breaking international law for the sake of an electronic document? Secondly, they haven't yet reached agreement on how to define goods that are at risk as they move from GB to Northern Ireland of entering the Republic of Ireland over the open border and therefore go into the EU. We have no idea how these negotiations are going, because the government has maintained complete radio silence. We don't know what proposals they have put for defining goods at risk. We don't know what the response of the EU has been. The third question is state aid. Everybody knew that state aid rules would apply to Northern Ireland, but there is, I think, this legal concept of a reach back. Will it then also affect state aid given in the rest of the United Kingdom? Now, either the government knew that when it signed up to the protocol, or they didn't, or they only discovered a bit later. And then finally, this issue that came out of nowhere, third country listing, where in order to sell certain foods and animal products to the EU, you have to be listed under the third country arrangements. Now, the EU has denied that they've threatened not to list us. It would, in my view, be extraordinary if they didn't list us, because they know perfectly well what our rules are today, and they'll know what our rules are on the 1st of January, because they're not going to change. And that then the Prime Minister used to say there'd be a blockade of food going into Northern Ireland, which is completely absurd, because who's going to stop the food getting off the lorry as it is heading towards Belfast or Londonderry? To be honest, words fail me. On the state aid issue, it links across, and this is the final point I want to make, because you wanted us to be brief by way of openers, it links across to the negotiations, because there are 2 outstanding questions. One is fisheries, and the second is state aid competition rules. Now, on fisheries, that was always going to be and will be the last item on the list, because it's something that we have that the EU wants, and therefore the government isn't going to move on that until it feels it has secured everything else it would like. It's asking for, in one sense, not a lot in relation to trading goods. It's a pretty thin agreement if we get one, but in some other respects, which have received no publicity at all, on mutual recognition of qualifications or movement around Europe to provide services, it's actually asking for quite a lot. And that's not what has been provided to countries like Canada and South Korea and Japan. But on state aid, if the government were to publish what its rules are going to be, which it said at the start of the year it would, then it would help, I think, resolve the negotiating difficulty, because the EU has moved from its opening position, which was you've got to follow our rules, that was never going to work. And the EU has now finally accepted it's not going to work, and it's been reduced to rather plentifully saying to the government, would you be so kind as just to give us an inkling of what your state aid rules are going to be and how you're going to enforce them? Because although the government has said we'll follow the WTO rules, well, that's no surprise, because we'll be a member of the WTO. Of course, we're going to follow the WTO rules. But the latest position is that the government says it will publish its proposals probably next year. Well, that's too late for the negotiations. So they need to get their skates on, because, and this is my final point, the prospect with COVID, the economic recession, the economic disaster, frankly, that we are facing at the moment because of the impact of COVID, the idea that you would add to that no agreement, which would result in tariffs that would damage the farming industry. The farmers have called it catastrophic. 10% tariff on cars. What's that going to do to the future of the Nissan plant in Washington? Is frankly unbelievable. And it's not much good for the European Union, or the impact is much worse on us. It's also terrible for the Republic of Ireland. And the negotiators should stop posturing, briefing against each other, get on and do their job and get an agreement, because in my view there is still time to do that, because we do not want to come to the end of the year where it is announced that no agreement has been reached at all and tariffs have to be charged, because this is going to be very bad for the relationship between the United Kingdom and its biggest trading partner. And to reach the end of the year having managed to throw away our most preferential trading agreement, having negotiated an effective border in the Irish Sea and paid billions of pounds for the privilege, would hardly be a triumph for British negotiating diplomacy. So get on with it.
Thanks very much, Hilary, and for especially for that overview of where we are with Brexit, which is very helpful. Can I now ask Angela to say a few words? Very interested to hear about her work on the Treasury Select Committee, looking at the economic impact of COVID. I had a quick look on the website just now, and there seemed to be a huge number of evidence sessions. You seem to have spoken to pretty much everyone about it. So I'm very interested to hear what you have to say.
Well, thank you, Omar. And the Treasury Select Committee worked almost completely through the lockdown, doing virtual hearings, and we've managed to do now 2 reports on the effects of COVID, and particularly the response of the Treasury with their emergency measures. And we've also focused on those who've been excluded from getting the help that was made available to others, just by nature of, I think, the differential employment status that they have, or the sectors that they happen to be in. So some people have been able to be helped by furlough, whilst others have got nothing because they're self-employed or they have different employment statuses. And I think this has thrown up a great deal of questions about the sustainability and fairness of the systems in our labour markets that have developed. They call it the 3-body problem. I think the different entitlements that you get if you're self-employed, if you're employed directly, the different tax payments, etc., how you take your wages if you're incorporated, and all of those things. We all know that the huge exogenous shock to the economy that's been caused by the arrival of the pandemic is probably the greatest that the global economy has had to bear for 300 years. We saw the quite astonishing fall in economic activity of nearly 24% in April alone. And I suppose the only issue really which remains to be seen is how the shape of the recovery, whether it's V or W or the sort of Nike swoosh that people talk about, i.e. you have a big plunge and then you don't really recover very well. And the other big unknown is how much permanent damage will be done to our economy, whether we'll have a V-shaped recovery and it'll have been a sort of in a coma for a while and then revive, or whether when the patient wakes up, you'll find that they've got various after effects that you didn't know about. The main one that people are worried about, obviously, is a huge increase in unemployment and scarring in the labour market. I think the thing that very few people realised at the beginning, but is now dawning, is that the uncertainties thrown up by the pandemic mean that that recovery is unlikely to get us back to where we were. In fact, there will be damage to the extent that uncertainty about the onward progress of the virus, the need for ongoing social distancing and limiting economic activity in order to protect health, the extent to which that goes on into the future, the how long it takes us to get a vaccine if we're going to get a vaccine, and how long it then takes the world to be able to disseminate that vaccine to everybody is a part of the issues that are about whether we will recover or not. I think there are some other issues too as well. One is, to what extent has the pandemic brought on change that was going to happen anyway much faster? And we are using one example of that with our conference today. And those of us who've been zoomed out in the last few months will know exactly that using these kinds of technologies and meeting virtually has been increased massively. There are other things, for example, the almost complete sort of stoppage of using cash and the huge increase to electronic commerce and money is obviously been accelerated by the requirements of the virus. And when people say, oh, well, credit card spending is back up to where it was before, well, that might be because people are swiping their credit cards and there's no cash being used, or much less cash being used. That doesn't necessarily mean we're back to where we were. And certainly economists are talking about the largest levels of unemployment if the furlough scheme isn't somehow adapted that we've seen since the 1980s. And we have a government that's not exactly shown the best sort of capacity to do new things quickly and effectively. So quite what they'll do about unemployment with a half-baked universal credit system and a range of emergency measures which the Chancellor clearly wants to exit from in October, just as a second wave may well be reaching its peak, gives us great pause for thought. I just wanted to say a couple of things about the combination of these two things together, Brexit and COVID, because it's the perfect storm. And I don't think, certainly on the Treasury Select Committee, we haven't really been allowed by our Conservative majority to talk a lot about Brexit. But this double whammy could end up having a much greater effect when put together in our ability to cope, because basically COVID-19 has meant that everything is up in the air, but Brexit means everything else is up for grabs as well, and there's total uncertainty around what structures we'll be using, what kind of rules and will be expected to abide by. And we have a populist government that's really coming up against, which has relied on lies and rhetoric to get elected in the first place, on selling incredible visions that had no relation to reality, has come up against the realities of Brexit, which are crystallising and will inevitably crystallise by the end of the year, and the realities of a virus which basically kills people. So you can't sort of advertise your way out of that, really. And so I think that these hard realities have come up against a government and a Prime Minister that care little about the rules, that wanted to force Brexit through by actually ignoring the unwritten rules of our constitution. And you as lawyers will be all too well aware that our unwritten constitution requires a great deal of self-restraint and decency for it to work, both within political parties and their structures, and with our constitution and the way that Parliament works. And we've seen this particular government, the particular bunch of people who are running what is no longer a Conservative party, actually just not abiding by any of the rules, breaking every rule, breaking every expectation, proroguing Parliament illegally, criticising the judges when they point out that it's illegal, purging their own party of people who didn't agree with them, running the Conservative Party like it's never been run before, all of which has an effect on our constitutional settlements. And I think, this may be something that as lawyers you want to hear, but I think that the time of unwritten constitution and self-restraint is over, and we need to start to be thinking about what we can do to prevent this kind of running roughshod over standards and expectations in a way that it verges on totalitarian approaches to things very quickly indeed.
Thank you very much, Angela. Well, just on that constitutional point, it's actually interesting in our Fringe yesterday with the Law Society and the Bar Council, Charlie Faulkner, who was involved in the Constitutional Reform Act that set up the Supreme Court, was saying basically essentially the same thing, that we have to start asking about whether a written constitution is needed for the reasons that you've just outlined. I think also on Brexit and COVID, kind of the double whammy effect. I did actually want to initially call this event Brovid and Financial Services, but apparently that's not a common term yet, and so wiser heads prevailed. But let's see if that does come into wider usage in the next few months. So now I'd like to hand over to David Greene to talk about his perspective as Vice President of the Law Society. Obviously, Brexit is a big challenge for lawyers as well. I'm certainly aware that if you're someone who advises on in lots of areas where a lot of our lawyers, basically EU law, you advise clients who operate across the EU. It's the 1st of January could be a bit of a challenging time. So I'm very keen to hear David's thoughts.
Thank you, Omar. I attended that Fringe meeting yesterday evening in relation to and heard Charlie talk about a written constitution. I think it's an interesting debate to be had. I think there are lots of factors to be taken into account in a complex point about a written constitution. I did this similar event, I think, last year in Brighton. And I'm sorry that we're not all together this year. I've been a Labour Party member for 50 years or thereabouts, so quite some time, and party conference is always rather special to me, so I miss that. However, there we are, we're on Zoom or Teams or for the brave house party, for those not concerned about security. But I come here as a political neutral on behalf of the Law Society. So politically neutral, I would say, but not neutral. We speak on behalf of our members and the problems they are currently facing and will face after the transition period, in representing those suffering in these times. So those subject to domestic abuse, those facing eviction, those facing business collapse, immigrants facing expulsion, and those accused of crimes waiting on long delayed trials. In short, as I think it has been put recently, we represent activist lawyers. But we're also not neutral in relation to the rule of law, and protecting and promoting the rule of law is at our core. And where it's threatened, we have to speak out, as we have most recently in relation to the bill currently coming before the House today. And it is absolutely vital that we lawyers do not shy away from protecting the rule of law. Turning to services, the heading of this is financial services, and I will touch on services, particularly legal services. I'm going to leave to Anneli the technicalities that she's much more skilled and knowledgeable than me to deal with. But I will bring today a vision of the way in which legal services fits within that, and what we've been asking the government for in relation to legal services since the Brexit debate started, and particularly now. Unfortunately, it looks as though either a no deal or a very limited free trade agreement is the almost inevitable outcome now, bearing in mind the time. And the difficulty for us, and I know Anneli will talk about this, is that in free trade agreements, some services are dealt with in a very minimalist fashion. If we look at the Canadian agreement, there's a very limited provision in relation to the provision of services. And there are particular trading reasons for that. And what we must remember is that London, the UK, is a world leader in relation to financial services, and it employs about 1 million people in the UK. At least 2/3 of those are outside London. So it is a very essential part of our economy. I think in economic terms, it accounts for about 80% of our total economic output. So a very substantial element of our economy. Of course, COVID has had a huge effect over the past few months on services, and we only need to see that in our high streets and otherwise. And I can talk about what's happened in relation to legal services. Legal services is worth about 60 billion a year, 60 billion pounds a year. And our exports of legal services are about 5 billion. And legal services alone employs about 500,000 full-time employees, something in excess of 500,000. So again, an essential part of the economy. England and Wales, this jurisdiction particularly, it is very much one of the most prominent global legal centres for world trade. And indeed, both now and post Brexit or post the end of the transition period, we will remain and have always been a very open jurisdiction. And that is an essential part of what we offer, is being an open jurisdiction. So we have 200 foreign firms in the UK, 2,700 registered foreign lawyers. And as I say, our exports, net exports, are about 5 billion a year. There's no question that the end of the transition period is going to have a significant effect on UK lawyers seeking to export services, and particularly those UK lawyers attempting to undertake work within the European Union. What we've been doing over the past months is seeking to establish a freedom for UK firms, UK lawyers to trade in the European Union, whatever the outcome at the end of the transition period. And there we face considerable hurdles. What we find is that other centres in Europe, such as Brussels, such as Paris, are receptive to the concept of allowing UK lawyers to practice within there. Others have been a little more difficult, and it's particularly, the structure is that if a city wants to establish itself as a global legal centre, then they need to attract lawyers from all over the world, as we have. And therefore, we get a reception from the likes of Brussels and Paris that are attempting to do the same. So we're having discussions with other bars at the moment, and the one thing that actually brings us together with other bars, the same across the world, is actually the current circumstances in coronavirus, because it presents very similar problems to lawyers and their clients throughout the world. For instance, the closing of courts, access to justice, the ability of law firms to work. These are very common problems. Technology, virtual courts, all of these problems are faced very commonly by lawyers throughout the world, and particularly within the European Union. So when we talk to other bars, and I'm about to do a presentation to the French bar this afternoon, and when we talk to them, we seek to deal with those common problems. Can I mention two other things? First of all is that I have to mention the word Lugano, because that has become a big issue for lawyers, and we've been making submissions in relation to Lugano. Lugano is a convention that allows us, that deals with jurisdiction and enforcement of judgments across European Union borders and EFTA states. It is a replacement for the Brussels regulation. The Brussels regulation deals with exactly the same issues, but within the European Union. That is a single market instrument, and will go, and we need to replace it with Lugano Convention. The UK applied to ascribe to the Lugano Convention, I think in April. We persuaded the government to do that, but the European Commission is using it as a political tool. If we get no deal, then the Lugano, we have no hope of the EU approving our membership of Lugano. If we get a deal, we still need to persuade the European Union, the Commission, to ensure that we're entitled to ascribe to Lugano. And it's a really quite important instrument, and I'm sure you'll hear that from many lawyers along the way, and I'm sure Anneli might mention it as well. Just deal finally with COVID. So what are we seeking now at the moment in our campaigns? Safe return to the office, the ability of our members to go back to the office, their safety and the safety of all those working within legal services, helping keeping businesses going, and we have seen severe pressures on firms dealing with criminal justice. And they have had significant problems over the past few months, and we can discuss those in the way that we are seeking to ensure that they can keep going and we provide access to justice. Helping members stay compliant, but finally protecting the rule of law. And coronavirus has presented substantial problems for the rule of law. The courts have not been open, so access to justice has been affected. The statute itself affronts elements of human rights and civil entitlements, and we need to keep an eye on that. And defending our members and judges. As you've been talking about, judges being criticised for judgments in relation to the current crisis. And indeed, we saw it with in Article 50, enemies of the people, and we see that attack on judges, and we have to defend their entitlement to deal with matters. And indeed, now we're just seeing is the judicial review, independent inquiry into judicial review starting now with very swift submissions to be made. So from our point of view, the rule of law, as has been said, has been placed centre stage, and it is a significant challenge, and it's our obligation to translate what the rule of law means, and secondly is why it is such an essential for a democracy. That is to come. I'm going to slip into the water as president in about 3 weeks with barely a ripple. But when it comes to the rule of law, we've got to make waves.
Thank you very much, David. And we're, of course, very much looking forward to you taking up the role of President of the Law Society. Just on that Lugano point, I think yesterday, in the Fringe yesterday, maybe Charlie Faulkner or someone else said that one of the implications of the way that the government is behaving on Brexit is that one of the things that might happen is the EU might try to block our entry into Lugano. You know, that would obviously be a huge problem. So now I'd like to hand over to Anneli Howard, who has been, I think, right at the center of some of the most dramatic parts of Brexit and the law, to talk about the legal aspects of these issues. Thank you.
Thank you very much. Thank you very much for inviting me to speak today. We're now 4 years into the Brexit process, and it is a little bit like peeling an onion. And as you lift the layers and layers, the layers of irony reveal themselves as increasingly the government is having to face up to hard reality. And this is all culminating, obviously, with the Internal Markets Bill, which is before the House this week. What is really going on here is the concern about the level playing field. And these terms are being bandied about with no one really understanding what they mean and what the underlying core can often mean. So everybody's focusing on state aid, but actually the level playing field is a wider issue. So it covers not just state aid, but also competition law and standards. It's actually really about what standards apply to the UK as it leaves the EU, and how those standards are determined. Are they going to be determined as part of a collaborative process of across different member states, or involving different parliamentary and governmental bodies, consultation, inclusiveness, or are those standards going to be decided by a rather small, narrow group of people without much external oversight or input? And one of the first ironies of Brexit is really losing the single market, which obviously Margaret Thatcher was the key proponent of 20 years ago, and Britain has used and become incredibly successful at deploying the internal market, especially in the area of financial services. I mean, financial services has been the dream child of the internal market, and the EU regime that has been developed through collaboration during the last 20 years has created this pan-European passporting regime, which is unique to the EU. That standard of being able to operate across 31 different EU states is not replicated in any free trade agreement around the world, certainly isn't replicated in the WTO. And it means that you can be authorized and regulated in one state, but have the ability to seamlessly provide those services, and so financial products, insurance products, on a truly pan-European basis. And you have to compare that to a regime previously, which we were now moving back into, where each set of standards that apply are going to be determined on a national by national basis. So you have to comply with 31 different sets of rules and regulations to be able to apply bilaterally from the UK to each of those states. And don't forget that, particularly in these fields, these regulated fields, there are often criminal consequences that apply if, for instance, you offer insurance services, but you're not authorised in that particular state. But Brexit means Brexit, and we are obviously not wanting to have any passporting regime. We're going to have to apply on a national basis for authorisations, or we are highly dependent on a political decision from the European Commission of equivalence. And that is a decision which looks at our standards and our regulation and says, yes, you know, there is a relationship of mutual trust here. We can rely on the UK to deliver equivalent standards to those in the internal market. But it is very much a political decision, and it is highly dependent on goodwill. And so the more we ratchet up the temperature of the negotiations, and burn that goodwill, the chances of getting that all-important declaration of equivalence diminish. And importantly, this is not just in financial services, it does apply across the board in many different specialist sectors. So that may be aviation and transport, it may be pharmaceuticals, it may be telecoms. There are all these areas where the whole regime has been set up through collaboration and cooperation between different states, where you have specialist regulators and experts devising the policy together. In the words of Advocate General Bobeck, everybody's in the kitchen cooking together. They generate the rules and the policy, and they also it extends more into also decisions on enforcement. They are achieved through collaboration. And so we are opting out of that. And the immediate question is, well, what are we going to replace it with? And if you look at the terms of the EU Withdrawal Act, certainly for the holding position, we are replicating the entire rule book of the EU into our domestic statute book, which extends beyond just the legislation, the directives, the regulations, but into the decisions, into tertiary guidance issued by the European Commission, which only begs to wonder, well, why, if Brexit means Brexit and we're achieving independence, why are we replicating the whole of the rule book into our domestic law to hold on? And how are we going to create and redesign our own regulatory frameworks and enforcement mechanisms to replace those that the EU previously controlled? So we've got this huge upheaval ahead of us on the Brexit front in designing all of these regulatory frameworks and enforcement going forwards. We're going to end up, if we do get a deal, it's going to be pretty much wafer thin. And that's partly due to timing, because normally it takes 7 years to negotiate a free trade agreement. Then it has to be ratified. We have had 1 year to negotiate and ratify with no extension. And the terms of the draft documents that are issued both by the UK and the EU are very rudimentary, particularly on services. And in effect, the reality is that it's equivalent pretty much for no deal. For large sectors of the service economy, there's actually no difference between the proposed deal that we're going to get and the no deal WTO framework. Because the level of services provision in the WTO is rudimentary compared to the EU. There is a general clause on non-discrimination, but all the states have wide-ranging discretionary powers to put up barriers to services, which there is a low threshold to justify them. And that is an important part, because states are quite protective over their service industries. Singapore, for instance, does not want UK lawyers coming in and setting up the offices there. It's very tightly controlled who's allowed in and how they can practice. And that's the way in which the WTO is set up. We also, the other problem with the WTO is obviously the dispute resolution process is pretty broken at the moment. So there is a long time to resolve, and the sanctions are very blunt. So if there is a breach in one area, one sector of the economy, which is found to be a breach of the WTO, the retaliation can be in any other sector of the economy. So it's not like for like. Now, many businesses in financial services have obviously managed to mitigate these risks, and they have set up headquarters in other EU states in order to maintain their passporting regime. But what that means in times of COVID is obviously these businesses are being expatriated, and there will be a loss of UK jobs in the financial services sector, and a loss of UK tax revenues, which are the very revenues that we will be needing in order to build the COVID recovery. Now, you may cynically say, well, hang on a minute, we're not going to shed tears for bankers, but it will feed through down the whole economy. So as David was saying, you've got a circle of industries which surround the financial centre. You can only see that with COVID, walking through London and looking at the impact that the shutdown of the economy has had. So where does this take us with COVID? Because the ultimate irony of the level playing field is that all this focus is being played on state aid. when the UK has never been a very high proponent of state aid in any event. If you look, particularly now in times of COVID, there is total regulatory flexibility over state aid. The Commission has issued statements allowing states to grant state aid to all sectors of the economy, even to individual businesses. And if you look at the page of the document that the Commission has issued of the authorisations that have been given, over 70% of those have been issued by France and Germany, Italy and Portugal and other member states. Britain has had incredibly little support and granted very little support to its businesses. It's had economy-wide protection, but it hasn't for the likes of granted state aid to British Airways, whereas Germany has been propping up Lufthansa and France has been supporting Air France. All the others have basically renationalised their airlines. So here we are standing up for the freedom to give state aid when there are actually no regulatory impediments at the moment to state aid being granted anyway by the EU. And the other irony is, of course, that in the UK-Japan free trade agreement, which has just been agreed, the government has rolled over the existing EU state aid arrangements. So there are actually higher restrictions on state aid in the UK-Japan agreement than there is under the Northern Irish Protocol. So we seem to be pinning everything to the state aid regime, which makes you wonder what is real underlying rationale for this and for the freedom in the Internal Markets Bill, because it doesn't seem to be logically or coherently justified by state aid concerns. And I feel the wider concern is actually the freedom over regulatory standards and how those processes should be defined and issued. But I'll stop there and then we can maybe take some questions.
Thank you, Anneli. That's really very, very interesting, especially that last point. So if anyone has questions, please put them in the chat. We've got about 10 minutes, so we'll try to fit in as many as we can in that time. I'll just kick off with a question for Hilary and Angela, which is, so in the Times today, there's an article which says that basically a number of the banks have started writing to their customers who are UK, British expats in the EU, notifying them that they will need to, move or close their accounts. And I guess this is kind of the reality coming to bite of Brexit, because it's all very well to say these people have to shut down their accounts and you have a plan for doing that, and the banks have been working on that since 2016 to prepare for this. But do you think that there might be a different view when the actual reality happens and people do get these letters? Do you think the way that, for example, the EU regulators might approach it might be different if for those groups, or kind of reality of Brexit v the theory, which is what we've had so far, really?
Well, I mean, just to say, I think that when you try to disintegrate 40 years of integration, if you can do it in a friendly, agreeable way, which allows you to at least have some cooperations going forwards, then that's best. But if you have a bitter and vicious divorce, and it looks like we're heading for the latter rather than the former at the moment, then very many petty things can be done. And what you would normally expect, which is a period of sort of realism and mutual cooperation for mutual interest, can sometimes be lost in the sort of acrimony. I suppose my worry, Hilary may have more detailed sort of view of this, but my worry is that that's where we're heading, and the European Union just fed up with the grandstanding that they're seeing from our government, the replacement of the negotiators with somebody who also wants to grandstand. So they feel that they can't really get a grip on what's going on. And the collateral damage are the people that have to close their bank accounts and reopen others and suddenly realise that what they thought wouldn't happen is happening.
Well, just to add to what Angela has said, interestingly, I mean, we've taken evidence on a number of occasions from the representatives of Brits living in the EU, and the closure of their UK-based bank accounts, I cannot recall having come up as an issue. Now, I don't know whether these letters that it's reported have gone out are the first indication there has been. I was just looking at the story, and it's only certain banks. Is that the approach that all banks who have customers with them, but who live UK citizens, but who live in other EU countries, are they all taking the same approach? And I must confess, if any of the lawyers on the line would like to explain exactly why that is not possible. We haven't touched on the question of data transfer and data adequacy, but one of the other things that will be really important for a lot of businesses is a regulatory decision from the Commission. It's a bit like third country listing for the sale of agricultural products. People at times have talked about a data adequacy agreement. Well, there can't be an agreement because it is a regulatory decision of the EU in respect of a third country as to whether our rules will be sufficient, adequate to allow the continuing transfer of data. Now, there's a fallback in certain circumstances, standard contractual terms, but that's, I think for big companies, they'd find it easier to operate that. For smaller firms, they'd find it a lot more difficult. But I would be very interested in an explanation as to whether this is the approach that all banks that hold accounts of UK citizens living in the EU are taking, and if not, what is the reason that the banks who've written to these customers are giving for why they've got to close the accounts?
Yeah, I think that, so there are a lot of nuances in that, which I'm happy to just talk to you about, or Anneli can talk to you about maybe afterwards.
Okay.
We've got 3 minutes left,
okay.
but it's obviously a good, a reasonable question. So I think we're going to have to wrap up because we're short on time. So I'm going to be strict and suggest that everyone give us 15 seconds of final thoughts in a kind of quick fire round, by which we should add, we should finish then by 9:30 on the dot. So I will start with Hilary, I think.
My rational side says we will eventually get a deal, because why would politicians in current circumstances not want to get one? But I'm afraid there's always a possibility that things will continue to go spectacularly wrong.
Thank you. Angela?
Yeah, I agree that the potential for going spectacularly wrong is now higher than for escaping. And I think we've got to look beyond some of the sound and fury of what's going on at the moment to try and maintain at least some part of our reputation so that we can recover and begin to do more sensible things when this government is over and this Prime Minister is over. We need to try to limit the damage, maintain our contacts with our European friends and neighbours, and see what we can salvage.
Thank you. And David?
Yes, as presidents, we come in and we have some themes, and certainly my theme after these events is going to be rebuilding trust. Rebuilding trust between nations, rebuilding trust in the rule of law, in judges, lots of things, rebuilding trust. I think we will be placed with significant challenges to that if we don't come to some form of agreement with the European Union. And I think that would be a really major barrier to us in the coming years.
Thank you. Anneli?
Yes, I would just caution against, I think skeptics say, oh, we can go no deal, and then the EU is going to be so desperate we'll be able to have a whole series of mini deals on particular segments. I don't think that's going to happen. And similarly, I think they can get a wafer deal and then they can ratchet it up and improve it over time. I would caution against that as well. So, you know, it's imperative that we get some minimal deal, but then I really think we need to focus our energies on how do we recover both from COVID and Brexit for the long term.
Great. Thank you very much, everyone. I think a really interesting discussion, and I've realized that I should have probably organized this meeting to be a 2-hour meeting rather than a 1-hour meeting. But I'm sure there'll be more opportunities to discuss these issues, certainly within the Society of Labour Lawyers. If you are not a member of the Society, please consider joining. You can just go to our website, if you Google Society of Labour Lawyers, and join. And we've also got a Fringe event tomorrow morning at 8:30 a.m. With a range of speakers talking about COVID and the impact on the justice system. And this is like really central stuff. I think was, as David was talking about, you know, what happens if you're being evicted? What happens if you're being made redundant? What happens if you have family proceedings in the family courts? You know, these are all things that go, or if you're a victim of crime, or you are accused of a crime. These are all huge things that can impact people's lives. And the justice system was already on its knees due to austerity, and COVID has made the situation even worse. So we have a number of lawyers working in criminal law, family law, employment law, talking about their experiences of the pressures of COVID, but also what's worked well on the technology side, and what could be, and what things we should kind of retain, what things we should try, what things where we should go back to how things were before. So it should be a really fascinating discussion. So that's 8:30 a.m. tomorrow morning on the Connected agenda. And finally, just another thank you to Anneli, Angela, Hilary, and David for their brilliant contributions.